16-1-391, State of Hawaii versus Mike Ruggles, for further jury trial. Please state your appearances.
Good morning, Your Honor. Deputy Prosecuting Attorney Rick Somerville and Hawai'i.
Good morning. Good morning, Your Honor. Mike Ruggles, pro se, with standby counsel, Sure. Good morning, I think. Good morning, jury, and thanks for hanging in there with me. I'd just like to address, I have a written closing statement, but I wanted to address a few things Mr. Danville brought up before I get to it. First off, back pain. You felt like the doctor, he said he found it disturbing that all someone needs to do is get a medical cannabis is to say you have back pain. It's the same for any other medication. There's no way for a doctor to prove if somebody's in pain or not. Do you really want to live in a world where doctors don't believe you when you say you're in pain? Okay, he says that if just asking someone if they want to buy cannabis is an entrapment. And I'd agree with him. Asking somebody if they just want to buy cannabis is an entrapment. But lying to them and saying that they have a medical card and then going and getting a medical card before you come back to get it is entrapment. Let's see, he said, I sold the pen and the cannabis. We've already proven the pen and the cannabis wasn't mine. He said, yeah, $11,000, $12,000 went through the club every month. Yeah, it did. Went through to the other patients. I never kept a dime. My accountant showed you I never made a dime. In fact, the collective owed me. And any money that was saved was used to buy lab equipment and all the stuff that medical patients needed to get safe access to cannabis. And let's see, what else? Wasn't selling, was transferring. He went and got a car. I was a caregiver and a patient, and this is a good point, because before the law changed in 2015, he's exactly right. You can only have one patient, you can only caregive for one patient. And so what I used to do, and back when we were a club, and just to point out, and that letter I sent to collect, I'm pretty sure that was in 2013 before the law changed. And how that's important is this, is that the old law used to say, distribution is limited only between patient and caregiver, dispensaries are illegal, and clubs are not authorized. And so in 2013, we weren't a collective, we were a club. The difference being collectives private, a club's open to the public. Yeah, in 2013, we went around as a club and tried to get safe access for medical patients in the state any way we could. And I'm glad he pointed out all these letters. Yeah, who did we send letters to? Everybody. What were we trying to do? Was this some kind of money-making scheme or something? No, we were just trying to find safe access to safe medicine for sick people any way. There was no other way. Under existing law, we can only, as he pointed out, he said, well, how does a patient back then get cannabis? Well, you just got to go get a caregiver. How does your caregiver get it? You'll notice, is there any way for any caregiver to acquire medicine legally in the state back then? There was not. We were trying to correct that. Since 07, when I came on this, so 15, that was 8 years, we had a club and we were trying to establish a way for patients any way. We didn't care. I talked to the governor on down, as you'll see in these letters. We tried everything to try to be able to help people. And when they shut me down, broke my heart. And to this day, I still get 10 calls a week. People asking me, hey, can you help me? I'm dying of this, that, and the other. Can you help me? I cannot, and I have not been able to for 4 years. I don't understand why not. I didn't understand in 2015 how in a state, and to me, this is the worst part of this tragedy, is on the Big Island, we're the heart of aloha. We're the heart of compassion for the entire world. How can you carry on like this and purposely target medical patients for over 15 years, giving them absolutely no access to legal medicine anywhere, and then say, you can't get it from another patient who's authorized to have it, if you can't do patient-to-patient transfer in 2015, and if you look at your jury instructions, obviously you cannot, then how else were they to get it? How was any sick person, the people you saw on the stand, the one guy that said prostate cancer cured him, Mr. Clare, you saw him, he had cancer, his whole face. We saved him. Choice of evils. What if I hadn't gave him cannabis? He'd have been dead. He was on hospice. You can't get on hospice unless you got 6 months or less to live. He was one of the few that made it. Choice. I never made a dime. My accountant proved that, and in fact, the owed me money. All right. We're here today because I'm being charged with 2 things. Transferring 1.5 ounces of cannabis to an undercover who was qualified by position to have it, and a paraphernalia e-pen, which is legal for both of us to have and was probably available in every smoke shop in Hawaii in 2015. The government's expert witness, Lawler, testified that it didn't qualify as paraphernalia. That transfer was a legal transfer between 2 medical cannabis patients. In that transfer, I was acting as a warehouseman, facilitating the legal transaction. The prosecutor is going to assert a distribution scheme of, quote, marijuana, an illegal substance. However, it wasn't just marijuana. It was medical cannabis that was transferred to someone who was qualified to have it. The prosecutor, during his open statement, said there's no legal defense, no excuse for selling marijuana to someone who is not allowed to possess it without a medical marijuana card. He said this case is not about selling to people who have medical cannabis cards, or if I can transfer to qualifying patients. It's about that. This case, he stated, this comes down to the fact the officer Fontaine didn't have a medical cannabis card, and when he showed up, he acquired cannabis from me. But if you look at the jury instructions, obviously what he's saying isn't true. This case is exactly about whether or not patients can transfer to patients. But if you look at the jury instructions, they're telling you no, patients could not transfer. And that, like I say, patient-to-patient transfer. That is exactly what I was trying to establish for over 8 years. And when he told you that wasn't what this case is about, totally wrong. That's exactly what this case is about. I was trying to find a path up the cannabis mountain, just one path for any patient in the state. I wasn't just working for my collective, and yeah, I ran towards this. I had the video ad, I had radio ads. Why did I run towards this? I had a team of people helping me. I had a chemist guy, I had a registered nurse, I had an accountant. We were trying to do it every possible legal way we could. I never made a dime. These guys have been picking on sick and dying people in the year 15. Well, we finally got dispensaries this year. So for 18 years, where did a caregiver get, he said, all you need is a caregiver. Where do you get a caregiver? And obviously they can't, so you got to find someone nice enough to be able to do this for you for free, and then somebody who can actually get it somewhere. Where would you get it? If you couldn't get it from another caregiver, and you'll notice in the instructions you can't. If you couldn't get it from another patient, and you'll notice you can't. Where did you get it? Caregiver or patient? Was there anywhere to get it? In a state that said you could do it for 15 years. In a state that's the heart of aloha. Compassion, the law was compassionate use and an uninterrupted supply. How did stand silent in the affirmative defense ever fulfill the intent of the law? It did not. Dr. Berg told the undercover Fontenue in the tape, I believe you're going to see, it could take 68 weeks to receive his card. It's the collective experience that has taken up over to 6 months for some patients to receive their card. The entirety of the conditions of medical use under state law, that's all it says. It does not say the conditions of using medical cannabis or having a cannabis card. Nowhere does it mention or quote a card. This is the crux of the case. Mr. Danville said I violated statute by transferring medical cannabis to Officer Fontenue because he didn't yet have his card. However, state law says a doctor recommendation meets conditions of use. Not only does HRS 329121 say Officer Fontenue met conditions of use, but so does Hawaii Administrative Rules, Section 11-160-12, written certification, which Officer Bartz testified to. It said, quote, unless revoked, a written certification shall be valid 1 year from the time of signing by the physician or a shorter time if the physician recommends. That means it's valid from the time the physician signs the certification. Nowhere in any law or administrative rule does it say a qualifying patient has to wait to acquire cannabis until he gets his registration card. And you'll notice in your rules, if he would have had that card, you still wouldn't be able to give me the medical defense. So his reasoning for arresting me and the charge, as you'll notice, has changed now. And I can tell you this, for the 4 years I was fighting those other 31 charges, and in the back room of the judge, he said no. He believed that change in law was for dispensaries, not us, not for the patients. But yet that change in law was voted in 2013, didn't take effect till 2015, and dispensaries hadn't even been dreamed up yet. They were dreamed up in the year 2015. So how can a law that changed in 2013 been for dispensaries? But like I say, he's changing his tune. He says it's got nothing to do with patient to patient. It has to do with whether or not Fontenunu was qualified, whether or not the written certification. Now, in written certifications, let's see, he had a valid letter. And you're going to see in the evidence that the conditions for a written certification. One is you got to have a valid letter, and then there's 10 other requirements. Now, when you look at that letter in the evidence, you'll see in the upper left-hand corner a deposit slip. I mean, a receipt. And what that receipt showed was the money that he sent to the health department was indeed sent to the health department. And with that money went the other 10 requirements to make that written certification a written certification. All the patient ever gets is that letter. All Officer Fontenunu ever got was that letter and the registration card, which he did get 2 months later. So when he tells you a written certification is not the letter, he's right. When I tell you it is, I'm right, because it's the letter and the other 10 things that receipt shows went to the health department. The patients never get a copy of those other 10 things, never have, none of them. Me or Fontenunu. So when he's telling you that that letter wasn't a written certification, it absolutely positively was a written certification. And the fact that it wasn't a card has nothing to do with anything. That's just all subterfuge, or as Rick would say, noise. I didn't break no law when I passed that to him. Nowhere in any law or administrative rule does it say a qualifying patient has to wait to acquire cannabis until he gets his registration card. It also doesn't say anywhere that a patient can't use their medicine until they get the card. On September 5th, Officer Fontenunu had a written letter stating he qualified for medical cannabis use from Dr. Berg. Now, whether or not the prosecution thinks Dr. Berg is a good doctor, I can tell you this: he is a good doctor. He is a doctor, and that recommendation was valid. And it wasn't right for him to slam Dr. Berg, because he's a very good doctor. And yes, he did recommend our collective to other patients. And it wasn't some scheme. He may have made money. I will say this, and I'm not blaming the doctor. No, he got rich. I never made a dime. I was trying to help people. And I did. I saved lives. I was helping people. I felt good about it. I believe that's what Hawaii is about. Aloha. Helping people. We got a saying over here: if can. That means if you can help somebody, you do. Is it evil not to help people? Hell yeah, it is. Just recently they had some kids, 4 white kids, black guy in a lake in Florida. He was drowning. Help. They went, oh man, you should have thought about that, and they let him drown. Could they charge him? No. Was it wrong not to help them? Yes. Can I not? I kept getting phone calls. I got famous. You get phone calls, people are dying. You're not going to help them? He acted like I was just purposely trying to break the law. What are you going to do when you have a loved one bring someone up in a car? They're horizontal in the back seat and they're looking for a little relief. You're going to say, no, I can't help you because there's some stupid law that says I can't, even though medical patients They've had a program for over 15 years and gave us no way to do it. And then when you would try to do something, they bust you and charge you with 32 felonies and a misdemeanor. Why do they do that? To keep us from getting to this point. To keep me from giving you guys my story and their story. Medical patients for 15 years in 2015 had absolutely no way to acquire medicine. There was a change in the law. We thought it used to say distribution was only limited between patient and caregiver, just like it's saying in your jury instructions. It put a line right through that and said medical use. That's the new law. It was signed in 2013, took effect in 2015. Us and all our patients believed that meant we could finally do it. And I can tell you this, before that law changed, I totally understand patient-caregiver law. You can only have one patient. A caregiver can only have one patient. So what I used to do is when sick and dying people needed stuff, it didn't say how much time. So I would transfer. I'd have them come over and I'd have the person I was caregiving for say, Mike's no longer caregiving for me, he's caregiving for this new guy. And then I would transfer the medicine to them and then transfer the patient caregiver back to them. And we talked about it in the judge's chambers and I said, yeah, it sounds hokey. But that was the rules. What did it say in the rules? You could only do it for one patient at a time, but it didn't say how long. And so from 2007 to 2015, that's how we used to transfer to people. It was the only way we could figure out. And as you can tell, I went to Mitch Roth, I talked to the governor, I talked to the county council. All I was trying to do is get them to say, authorize this as a club, because it said in there, dispensaries are illegal and clubs aren't authorized. So to us, that meant, well, hell, we're not illegal, we're just not authorized. Who could authorize us? We sent letters to the governor, we sent letters to everybody, the health department, Mitch Roth, the county council, chief of police. We tried to get authorized, we tried to be legal. Please notice this, and please put yourself in the shoes of medical patients in 2015. Was there any other way to do it? No. How is that not entrapment? 20,000 patients in 2015, most of them on the Big Island, no way to do it. Not only does HRS 122 say that Officer Fontenot met conditions of use, written certifications, like it says, unless revoked, a written certification shall be valid from 1 year from the time of signing by the physician. Straight up. That means it's valid from the time the physician signs the certification. It doesn't say anywhere that the patient can't get the medicine. All right, I think we already know this. The rest is all noise, as he's pointed out. When the undercover didn't meet conditions of use, he was sent away. What did he do? He lied. They all did a lie. We'll get into that later. In a Hawaii administrative rule the prosecutor provides, he will not be able to show you any actual language of the rule that Officer Fontenot didn't have a right to acquire, or I didn't have the right to distribute for medical use. When someone forges a fraudulent prescription for Valium and acquires Valium from a pharmacist, they don't arrest the pharmacist, and they certainly don't arrest the cashier. That was me. I didn't make a dime. Was I the pharmacist? No. I didn't make a dime. I was transferring other patients' medicine to a guy who was qualified to have it. Why? He told me he was in pain and he needed it. Prosecution for the last 4 years has said distribution between patients was totally legal. Now suddenly in the last 2 weeks he changed his mind and says, we got nothing against patient-to-patient transfer. I'm sorry, for 4 years he said it was totally illegal. You heard the prosecutor say illegal. So did I think they thought it was illegal? Absolutely. Did I firmly believe that there must be a way for patients after 15 years to qualify to actually get safe medicine? I thought the new law changed it. So did hundreds of other people. And we're still hoping that it did. Obviously, that's not the court's or the prosecutor's opinion. He stated the case comes down to the fact that he didn't have a card when he acquired. Got nothing to do with it. Look in your instructions. Does it say anywhere in there that if he had a card, I could use the medical defense? No, it does not. Does it say anywhere in there if he was caregiving for someone else and had a card and came to me that I could have gave it to him? No, it does not. So obviously, card irrelevant noise had nothing to do with it. There was no legal way, and we didn't know that, but they knew that. And that's why they came and busted me. I agree with the prosecutor that you need a medical card to grow medical cannabis. However, I do not agree that you need a card to use, and this is why. Prosecutor asserts that I broke Administrative Rules Section 11-160-31, possession of a registration card. A, person to whom the department has issued a card shall carry the card. It says once you've been issued. Does it say you don't? If you don't have a card, you can't possess? No, it does not. First, the prosecutor says I broke the law by saying I was Officer Fontenot's caregiver. You're going to see the video. Never once did I say I was going to caregive for him. Did I ever suggest it? Did I ever imply that I was going to caregive for him? I was not caregiving for him, and I've said that all along. Yet if you look at the law, I don't get to use the medical defense because I was not caregiving for him. I never said I was. I never broke the caregiving law. I just want to make that perfectly clear. The E-pen, I never said was THC concentrate. Prosecutor's expert said it tested negative and doesn't meet the requirements of paraphernalia. Did the police set me up? Yeah. An undercover officer gave a doctor a fake ID and a real story about pain and got a letter of recommendation. The undercover called and said he had a medical cannabis card, had back pain, so I gave him directions. I gave him directions instead of a physical address because I have dyslexia and I can't spell. There was no physical address pointing. And I want to bring this up. He said you're going to see my house in the video. And yeah, it's a humble home. I've been a concrete worker. Concrete work is not steady work. You pour a slab, it might be several days before you pour another one. I've poured thousands of slabs. I've done dozens of churches. I did all the sidewalks in Kona. All those planters you see downtown, those used to be trash cans. When the tops rusted off, they made them into planters. I made all those. The benches at Tykes, the benches at the high school, the benches at the college, I made all those. All them planters and stuff you see at Planet Hawaii, I make those. So yeah, I'm poor. I don't have a car. I had a truck, but it thinks I'm stealing it, and I haven't been able to drive it for 6 months. But yeah, don't slam my house because I'm poor. I had a registered nurse, I had a chemist, and we did quality control. We had a gas chromatography machine, which cost $5,000, that we got just so patients could have safe access to safe medicine. And I never made a dime. Obviously, I asked the undercover if he had a card, because I knew if he didn't have one, it would be a waste of time for him and me as well. But he acts like I didn't ask him for a card. I guess they got their reasons for lying, but I don't believe they're valid. Officer Bart's and Leloy's police reports verify that the undercover left within several minutes of arriving. Neither Officer Bart's nor Leloy ever mentioned in their police reports that he went into my house the first time. Who's telling the truth? Will we ever know? Does it make sense to send an undercover who's on his first drug mission and English is his second language without a recording device? Remember the recording when he came up the second time and I transferred to him? How did they know I wasn't going to transfer to him the first time? How would they have proved it was a crime if they didn't have the recording? Of course they had a recording. Officer Bartz testified 3 times that they had a recording. One time was after he'd already wrote a police thing saying, hey, I went looking for it, maybe we don't even have one. I think you guys will see that. He testified after that under oath that he had one and he didn't know what happened to him. And I believe it would have proved I was innocent. I never let him out of the car, and I told him, hey, of course you can't obtain cannabis without a license. That would endanger it for over 150 sick and dying people. They hid that recording. And I think that proves that they weren't trapping me. Second time the undercover called, we were closed. And even though the collective was closed, I felt bad for him because I'd sent him away over a month before when the first time he came. And so I opened up for him. I was actually sick that day, and you'll notice my voice was raspy. And I hope you'll notice in the video, I also told Officer Fontenot 4 times that what I transferred to him was good enough. I was being responsible and encouraging him not to get too much, demonstrating I wasn't in it for the money. I did nothing different than your average Long's drug employee pointing out different kinds of medicine and what would be best for back pain. It was medicine, and we were trying to help Officer Fontenot, the patient. I was being transparent, and I wasn't trying to hide anything. This is evidenced by radio advertisements entered into evidence yesterday. The prosecutor is going to assert that all my witnesses had a card when they had medicine transferred to them. When Fontenot came up the second time, even though he didn't have a card, he met conditions of use and produced evidence that he was a qualifying patient from a physician I knew and recognized. And then Officer Bartz confirmed that he actually received undercover Fontenot's medical cannabis card issued by the state of Hawaii about 2 months after he saw her. Furthermore, the police went as far as videotaping Dr. Berg's office, along with patients waiting for an hour, and broke federal patient privacy laws. The fact that I turned the undercover away on August 3rd, 2015, the first time he came to my residence when he didn't meet conditions of use, proves that I was not predisposed to distribute medical cannabis to him illegally. When he showed up at my house the second time, he had proof that he was qualified to use cannabis as medicine. There's no doubt in my mind he was qualified. In the video, when Fontenot asked me for a discount on the e-cigarette, I told him I couldn't because it didn't belong to me. I was warehousing. Furthermore, what kind of drug dealer tells you when you have more than enough for your immediate needs? What kind of illegal drug dealer uses a cash register, gives receipts, and pays taxes? Hawaii State has a medical cannabis program. They take your money and issue your registration card. Yet they give you nowhere to get it. There were no dispensaries. The head county prosecutor, Mitch Roth, even said in 2015 that he didn't know of any legal way for a patient to acquire plants or medicine. I believed our collective was the legal way at the time for safe access to medical cannabis. The affirmative defense. That's really the problem. As the prosecutor already pointed out, when they decided to give citizens in Hawaii medical cannabis, they never changed the laws. They came up with what's called the affirmative defense. And I can't think of anything more unconstitutional than the affirmative defense. Listen to what it says. If you're not strictly following every rule, although they stand silent on how, you don't even get to bring up the fact that you had it. How is this constitutional? You don't get to tell the truth to you, the jury? And I want to bring that up. You guys are the first jury ever to hear a medical patient story ever in the state in almost 20 years. These rules, these jury instructions you got were written up now, right now. There's never been any jury instructions to any jury on a medical cannabis patient in our state. Why are you seeing it now? I was brave enough to stand up. Why? I'm standing up for them. Sick people. No, I ain't no rocket scientist. I ain't no word master like these guys. And if I'd have known there was this many words involved in this, I wouldn't even have tried it. But I can tell you this, I love people, I love the Big Island. I'm trying to fix this, not just for medical patients, for the whole state. Let's quit locking people up. I can tell you this, we're 80% over capacity in the jail in Hawaii, on the Big Island. They rioted 40% over in Maui. Well, we're nicer over here. They're 80% and they're not rioting. But I can tell you this, I was in there for 6 days and it damn near killed me. My kidneys shut down. It's rough in there. And that shouldn't be allowed. You should never be able to go. When my dad, who ran the jail in Las Vegas, when you were one guy over in jail in Vegas, they kick somebody out. You don't stack them in there 80%. Anyway, the affirmative defense, unconstitutional. What do you mean you can't bring it up? At least, thank God the judge finally let someone hear the medical defense. And I believe it was Stanton O'Shear that got that on. Because, 2 weeks before, none of this, you guys wouldn't have heard this. None of this was happening. I wouldn't have been able to even tell you. Imagine your mom has epilepsy, and it slowly got worse over time. She tried pharmaceuticals to help stifle the tremors, but gave her migraines and nausea. A friend told her to try cannabis. It calmed her tremors without migraines and nausea. She told her doctor. Her doctor says, maybe it's time for you to try cannabis and take a break from the medication, and writes her a recommendation. She pays the doctor $200, takes her recommendation to the health department, writes a check, $38.50. Takes 60 weeks to get your medical card in the snail mail. Do you really think it was the intention of the law that she should have to wait up to 8 weeks, as Bart's testified to, or even 6 months to be able to use the medicine her doctor qualified her to use? Using prosecutor's logic, she would have to wait for her card. However, I don't think that is what the law says or intended or would be a reasonable policy for the jury to uphold. Senator Ruderman talked about a Vietnam vet that had a pocket full of opioids and told him that when he can't get medical cannabis, this is what he uses, even though he doesn't want to. We have these police that know that the benefits of cannabis are, and then use that knowledge to trick a doctor into giving them a card for pain, and then trick me into transferring the cannabis to them. They know the benefits of cannabis, and we're using it to entrap sick people. Hawaii State has a medical cannabis, so they take your money and issue you a registration card. There were no dispensaries until this year. There were no dispensaries in 2015. In Mitch Ross' testimony, he even said that at the time he didn't know of any legal way. Besides the issue of a patient possessing a valid certificate or registration card, like the prosecutor is pointing out, this case has everything to do with the fact that the government has stood silent on how patients can acquire and dispose of cannabis, and the police and prosecutors are taking advantage of this, as you can all see. I've been concerned about the sick and dying people of the Big Island, and I've been trying to help. And I didn't try to make any money. To me, it is repugnant to try to make money off of sick and dying people. That is repugnant. That's what dispensaries do. Collectives are patients coming together for themselves. In affirmative defense instructions you were just provided, the element of distribution being limited to between patient and caregiver, and patient is from the 2014 HRS 329121 under the definition of medical use. If this law was in effect in 2015 when the collective was open, I would agree with the prosecutor that I broke it, because I was not caregiving for Officer Fontenino, and thus would have broke the terms of medical use as transfers between caregiver and patient only. However, Act 178 amended this law. These amendments took effect on July 2nd, 2015, and that's why we opened, because we believe we could start helping other patients, and that's why I believe I'm innocent. Act 178 amended 329121 by crossing out the limitation that distribution be limited between patient and caregiver. The legislation's intention was to remove severe obstacles to patient access. Law enforcement officials testified against Act 178 because it, quote, would allow patients to transfer amongst themselves, and they wouldn't be able to tell when a crime had been committed. However, it passed, and it took effect in 2015, the same year we opened. Even the prosecutor, during his opening, said this isn't about patient-to-patient transfer. No, that's exactly what this whole thing is about and what we've been trying to achieve for over 8 years and still trying to in 2019. Because even though there's patients, and he pointed out that the cheapest we were selling cannabis for at the collective was 125, I believe it was 100. I can tell you this, that you go to a dispensary right now, it's over 400 now. Why? Because they're making money. Our guys were not. 4 times as cheap. I never made a dime. Did a 10,000, 11,000 go through the collective every month? Yeah, it went to the hundreds of patients that were helping the other patients. We believe we could start helping other patients. That's why I believe I'm innocent. However, as a juror, you have the right to see the medical cannabis law that was in effect at the time I was arrested. You can request to see HRS 329121 that was in effect in 2015, and you can request to see Act 178, and I hope you do, because it's the crux of this case and how you'll know I'm innocent. Before the law was amended, I used to transfer caregiving from one person to another so that I could help multiple, because there was no time limit on how long you could caregive for somebody. That law changed in 2015, which is why I didn't do that for Officer Fontenot. I believe that Act 178 had amended medical use by removing the limitation that it be between patient and caregiver only and replaced it with the term distribution. As a medical cannabis patient, I didn't need to be a caregiver to transfer medicine to him, because he also was a medical cannabis patient, as evidenced by his letter of qualification from Dr. Burke. All right, I already went over what's if you look in the right-hand corner, the 10 other things that are required for the written certification. The patients never see it, gets sent to the health department. It all happens the same time. He was certified. Those 10 other things, as evidenced by the receipt in the upper right-hand corner, had been sent to the health department. So on August 5th, September 5th, he was certified. What if the undercover had been caregiving for someone else? Would it still have been illegal? Using the jury instructions, could I have helped him and still have a medical defense? No. So it has nothing to do with whether I was a caregiver or if he had a card in his hand, and has everything to do with whether patient-to-patient transfer was legal at the time. And remember, the prosecutor said exactly the opposite. He said, a quote, it has nothing to do with patient-to-patient transfer. If that was true, the jury instructions would reflect that. It would say, if you found he was certified by a doctor, then you would give me the defense, and not mention the caregiver law. But it doesn't say that. This is why the prosecutor was misleading you. He tried to insinuate that there was some legal way for patients to acquire medicine and that I just wasn't following it by waiting for Officer Fontenay to get his card in the mail. Now his story's changed. He's saying that I broke the law by not being Fontenay's caregiver. Please note the change in the story. Patient-to-patient transfer is what we were trying to do and establish for over 8 years. It was either patient-to-patient or patient-to-criminal. If it was caregiver-patient only, where did the caregiver get it? Apparently, they couldn't get it from another patient or another caregiver. So from a criminal. That means the only choice was a criminal. But if it was a caregiver-patient only, then that means they were trapping who? Everybody. All 30,000 patients, not just me, but every patient in the state, by forcing them to acquire from non-certified criminals rather than qualifying patients. Patient-to-patient was the only legal way in 2015, and that is why we're here today. I come from a long line of police. I believe we've already talked about that, grandma, mom, dad. I got law enforcement. I can tell you this. When my parents were police didn't pick on sick and dying people. And police didn't target sick and dying people. They didn't target and harass people that were helping people with debilitating conditions. Now, I don't know why this has changed, but this is why I stood up. It isn't right. As somebody who was taught to stand up against wrong, stand up against evil, to help sick people, help the weak, I had to stand up. Why? Because my whole life I believed your most valuable thing you can possess is your opinion of yourself. You have to be true to yourself. You got to stand up when you see wrong in your community. I love this community. I love Hawaii. I love the Big Island, and I'm trying to help. Not just these people, everyone. I knew it was going to be bad, but I didn't think it would be 33 felonies bad. I didn't think it would be this bad. The government keeps claiming that I was breaking the new Hawai'i administrative rules about a registration card. I was following the law, a state law, which takes precedence over administrative rules. That's what Mitch Roth told me and said on the stand. Laws are up here, rules are down here. I was following the law, he's saying I'm breaking a rule. I had concerns about the new administrative rules being unfair to patients in January 2015. I spoke these concerns to Peter Whitaker. You're going to see the video, or at least some of it. You'll notice he said that, quote, if that's what the law says, then you're good to go. The health department was supposed to, at that meeting, take the patient's, medical patient's concern and revise the rules to help patients, not law enforcement. Now, when you see this video, you're going to notice I was being rude. Because after 15 years of them standing silent, I was trying to get the head of the program to speak up and actually tell us how. After 15 years, I was angry and frustrated and was trying to get him to speak up. And so you'll notice, he didn't speak up until I got rude. It wasn't rude in the beginning, but at the end I got rude. He spoke up and he said, you're good to go. Everybody clapped. We believed that meant we could do it. And we opened up. I'm being charged with selling 1.5 ounces to an undercover who's qualified to have it. That 1.5 ounces I'm being charged with, while I was acting as a warehouseman, warehousing a legal transaction, the prosecutor is going to assert that this was a distribution scheme. All right, we already brought up that pins were sold all over the island and in the nation, and that his expert clearly pointed out that it didn't test positive and therefore wasn't paraphernalia even though he objected. Since my arrest, paraphernalia isn't even illegal in the state anymore, thanks to Tulsi Gabbard. She got rid of it, and we were the last state.
The state objects to that misstatement of the law.
It's a state. So the juries to follow the court's instructions to the law with regard to definition of offenses.
The judge went over presumption of innocent, presumed innocent, until they prove I'm not, beyond a reasonable doubt. The government has to shift the scales. They got to prove I'm supposed to be presumed innocent to the extreme of beyond a reasonable doubt. If not, you must acquit. If the prosecutor has convinced you that I've broken the administrative rule, that even with the doctor's qualification letter, Officer Fontenuna wasn't qualified to use medical cannabis, please know as the jury, you're the fourth branch of the government. If you don't believe what I did means I'm a danger to society enough to put me in prison, then it is within your ability and duty to say I'm not guilty. America's history is founded on checks and balances of the government, and you are the fourth check and balance for this government on outdated, unjust laws. You are able to say I'm not guilty if you believe it. I don't know if you noticed, but it was really difficult to get answers from the police officers. Why couldn't we get a yes or a no from the police? Why couldn't we get matching answers from the police? This is not a difficult case. Either they investigated properly or they didn't. As brought up in previous testimony, Officer Leloy and I have a history from 2012. There was conflict over he searched my property without a warrant. I filed complaints and filed harassment suits against him. Because I complained about and sued him, I believe Leloy's resentment toward me played a big part in why and how he started this investigation. I believe it was his attempt to retaliate from those complaints. And in one of the several compliance checks, we have a video of an officer specifically saying Leloy sent him. I firmly believe the government and Officer Leloy was out to get me, and this is very relevant to my entrapment offense. Leloy retaliated against the lawsuit by setting me up after waiting for July 18th, 2015.
At this point, the state objects to talking about what is clearly not an evidence in this case.
Your Honor, it clearly is an evidence. I can show you. I kept track of the camera over there, and I can tell you the exact minute he said this.
Okay, overruled.
Leloy insists, he retaliated against me in the lawsuit by setting me up after waiting for the July 18, 2015 administrative rules to take effect and assigning Officer Bartz to head the investigation on July 31st, 2015, distancing himself from the investigation as much as he could. Leloy insists that Officer Bartz, who decided to focus on this case, however, Leloy initiated the case on June 22nd, 2015. He did the medical check on June 30th, 2015, a full month and a day before he appointed Officer Bartz to lead the investigation. So that means that Bartz couldn't have done the checks and decided to focus on one property because he didn't come on the case until a month later. Let me also remind you again that Officer Bartz said he called the prosecutor hotline to confer and see if any laws were broken in this case. You'll remember Officer Leloy says he didn't confer with any prosecutor or hotline at all, and I believe it was probably Leloy who was telling the truth, because why did they get to charge me with 31 extra charges had they called the prosecutor to see if they were good charges? I don't believe they ever did, otherwise they wouldn't have charged me with 31 extra charges. So obviously they were going out of their way to get me. And the mere fact that if they believed that it was so wrong that I transferred Cannabis to Officer Fontenunu because he didn't have his registration card on September 5th. Why didn't they just arrest me right then? I can tell you why. They wanted to shut down my collective. They wanted to hurt all the people in it. I don't know why, but that's why they didn't arrest me right then. They went home and lied and got a warrant and came back and shut me down, took everybody's stuff, and then charged me with 32 felonies and a misdemeanor. In Fontenunu's testimony, he says all his reports were reviewed by a supervisor who was Leloy. Officer Fontenunu testified he was instructed by Sergeant Ian Leloy to make changes to his report. He testified that he was assigned to the case by Leloy, not Bartz. Yet Leloy kept referring to Bartz as the leader when in fact Leloy was. Leloy said Bartz first brought him the YouTube video, but Bartz denies that. Officer Leloy lied. In the April 26, 2015 transcript, Officer Bartz states, Detective Leloy had already viewed a YouTube video, initiated the investigation, and assigned him to it. Then on February 3rd, Leloy says him and Bartz watched the video together, and Bartz brought the video to his attention. The same February 3rd, then during Leloy's most recent testimony, he said he walked into a room with people already watching the video. Which version do we believe? The undercover's police report had been clearly changed. The electronic signature reflects it was Officer Leloy who changed it. Who did the undercover Fontenunu say told him to get a fraudulent ID and medical marijuana card? Officer Leloy. Leloy testified that Officer Bartz did 2 medical checks. Officer Leloy asserted he never did any medical permit checks and has stated multiple times that he was not confused about the issue at all, that Officer Bartz did the medical checks. Bartz testified he didn't do any medical checks. Why is this relevant? While questioning these police officers, you may have noticed I brought up what was called the rules and regs. I was referring to the Hawaii Police Department rules and regs governing investigations involving the medical or religious use of marijuana. On page 4, paragraph 5, search warrants. Before seeking a search warrant, officers shall check with the Department of Public Safety by name or location to determine whether the person under investigation has been issued a registry certificate. They did the check June 30th. They came to my house August 5th. They should have done new checks. Permits are only good for a year. I could have had more, I could have had less. He should have checked. When questioned about why he only checked one property, Leloy testified because there were new regulations, new rules and regs at the time. I'm pretty sure you guys heard him say that. However, there are no new rules. He lied. The rules and regs that were in his hand, the rules and regs that are on file, are the same rules and regs that are in effect today. Police don't normally lie, and there's a reason they lied in this case, and that reason is that I'm innocent. It was a setup, and they were told to lie to make me look guilty. Remember, I had filed police complaints against Officer Leloy. I had sued Leloy before they searched us. It was Leloy trying to get back at me. He used Officer Bartz and Fontenunu as a buffer. All right, I pointed out he waited over a month to come. He was waiting for these new rules to take effect. I don't believe I'm breaking them, but that's what he was waiting for. Furthermore, the government even went to the extent, I wrote that. So now I'm going to talk about my other defenses that I'd like you to consider. Jury instruction 7.08, entrapment, methods of persuasion. Entrapment is the affirmative defense to the charge of promoting a detrimental drug in the first degree, and any instructed, including offense, as well as prohibitive acts related to drug paraphernalia. A person is entrapped if he engaged in a prohibited conduct or caused a prohibited result because he was induced or encouraged to do so by a law enforcement officer. Obviously, I was induced and encouraged to do so by a law enforcement officer. Was I advertising at the time? Yes. On the radio, on YouTube, everywhere I could. But I was advertising for medical patients. We were not ever once saying we were selling cannabis, and in fact, when he came up and tried to buy some, I sent him away. If you're confused, that's called reasonable doubt. If you don't know I broke the law, as long as there's any doubt in your mind, I'm innocent. With all these inconsistencies in the police stories, I hope you find plenty of doubt. Entrapment, the two elements. One, the defendant engaged in a prohibited conduct or caused a prohibited result because he was induced to do so by a law enforcement officer. And two, the law enforcement officer did, for the purpose of obtaining evidence of the commission of offense, employ methods of persuasion or inducement which created a substantial risk that the offense would be committed by persons other than those who were ready to commit it. What did the evidence establish? Detective Leloy and Officer Bartz and Officer Fontenunu went above and beyond the police rules and regs and did everything they could do to get me to sell medical cannabis to them undercover illegally. What did they do to get me to sell medical cannabis to Fontenunu? Remember, first I refused and demanded he show me documentation that he was a qualifying medical cannabis patient and legally permitted to acquire medical cannabis. My refusal to transfer medical cannabis to him when he was unable to establish that he was a qualifying patient proves I was not a person who was ready to commit the crime of selling medical cannabis. On September 5th, 2015, when I did transfer medical cannabis to Fontenunu, because I was encouraged to do so by Fontenunu, a law enforcement officer. And what was the method of the persuasion which created a substantial risk that I would sell Fontenunu medical cannabis? He obtained proof from Dr. Berg under a false name that he was a qualified medical cannabis, presented his false ID and ill-gotten proof to me, and lied and said he wanted medical cannabis for his back pain when all he really wanted to do was arrest me for selling medical cannabis. The evidence is absolutely clear that the police only had one goal: get Ruggles and shut down his collective. If they weren't targeting me, why did they charge me with over 30 felonies which were dismissed by the prosecutor? The police have committed multiple lies and fraudulent acts to get me to sell them medical cannabis, which I wouldn't do illegally. If we consider Officer Leloy, we see that he was so motivated or driven to get me that he was willing to do anything and everything to achieve that goal. That included targeting me, leaving out information like, for instance, permit checks when convenient, and creating evidence and creating a situation through the use of lies and deception in order to trick me into believing that I was helping a qualified medical patient obtain medicine that would help him. How did Leloy do it? He used methods of persuasion which cause a person not otherwise inclined to transfer medical cannabis to, in fact, transfer medical cannabis. Recall, I initially turned Fontenunu away when Fontenunu couldn't prove he was a qualified patient. So what was the government's response? Make up lies, hide tapes, use deception, and order the undercover to obtain a false driver's license, take it to Dr. Berg, lie to him to obtain a medical cannabis certification, and then Leloy instructed Fontenunu to present that certification to me. Lie to me again about back pain, complain of back pain, all the while waving around his certification.
Okay, so Mr. Ruggles, we talking the bench for them.
Oh. He was properly induced or caused because he claimed he had back pain. That's not what he told Dr. Berg, that's not what he told me. He misled me to take advantage of my desire to help people who need to use cannabis for their ailments. And now the government uses that to charge me with crimes. Jury instruction 709, entrapment, false representation. Entrapment is an affirmative defense. A person is entrapped and is engaged in prohibited conduct or caused a prohibited result because he was induced or encouraged to by a law enforcement officer who, for the purpose of obtaining evidence of a commission, knowingly made false representations designed to induce the belief that such conduct or result was not prohibited. It's exactly what they did. Two elements. The defendant engaged in a prohibited conduct or caused prohibited result because he was induced or encouraged to do so by law enforcement. And that law enforcement did for the purpose of obtaining evidence of an offense knowingly make false representations designed to induce the belief that such conduct was not prohibited. We know they did that. What were they? The undercover wanted to be a qualifying patient so he could buy cannabis. The undercover told the doctor he had back pain. He told me. Remember that based on his representations, Fontenot was certified by Dr. Berg as a qualified patient. And remember, Officer Bartz testified that he did in fact get his card. Choice of evils. It's a defense to an offense charge that the defendant's conduct was legally justified. The law recognized the choice of evils. The choice of evil justifies the defendant's conduct if the defendant reasonably believes that such conduct is necessary to avoid an imminent harm or evil to another person, not yourself, as his example, on breaking into a house if you're cold in your car. No, this is a harm or evil to another person. This conduct is justifiable if the harm or evil sought to be avoided is greater than that sought to be prevented by the law defining the offense charge. I think it's pretty clear what the imminent harm or evil to another person was I was trying to prevent. You've seen all the guys I was helping on hospice. The harm and evil to Fontenot was his back pain. He lied to me and said it was. What was the evil that would have happened? What evil happened when I transferred that to him? Was there any evil? What evil could it have been? He had a card. He had pain. I gave it to him. What evil happened because I gave it to him? There was nothing evil. What evil would have happened if I hadn't gave it to him? He would have continued to suffer, and I would have continued to have to feel bad about all these people that suffer. Because as I pointed out to you, 5 or 10 people a week for the last 4 years have been coming to me suffering, and I can't help them. It's not right. It's not fair. I did everything in my power to make sure that the law was followed by me and even the undercover. I made him produce evidence. I upheld the law, was able to prove his qualifications. Choice of evil. You're faced with a choice, one or two things. You choose to do one thing that is less evil than the other. What evil was I seeking to avoid by transferring cannabis to him? His suffering. There is no other evil. The only thing he lacked was a card. The government is desperately trying to obtain a conviction in this case for one reason only. I've called attention to the deficits in the Hawaii medical cannabis system. Deficits that even Prosecutor Mitch Roth and Senator Rubin said existed. I went to meetings, I talked to everybody for 8 years. I think the evidence is real clear. They went too far and they trapped me. In 2015, the state of Hawaii had a medical cannabis program. It was taking patients' money, including mine, and issuing medical cannabis registration cards. As such, I believe in good faith that there was a legal way to acquire and maintain an uninterrupted supply of medicine as the law intended. I sincerely studied the law to determine how to comply with it. I believe I've put in more hours trying to understand how to comply with the medical cannabis program requirements than anyone, including Mr. Darrenville himself. I did this so that I and others would not be subject to arrest and prosecution. I learned that although the medical cannabis program is governed by both laws and rules, laws are superior to rules, and I noticed with regards to the adopted rules of the DOH that they overreached executively and have gone beyond the scope of the authority granted to them by law. I believe I follow the law and the DOH medical cannabis rules, although Darrenville alleged that I violated a rule and should not be allowed protection. It's worth to note that I was both a primary caregiver and a qualifying patient, and each license is separate and independent, meaning that I was licensed primary caregiver. I could grow 7 plants and distribute that cannabis.
So, Mr. Ruggles, why don't you consult with Mr. Bashir for a little bit?
Out of time. Appreciate your time. I appreciate your patience. Sorry I'm not a lawyer. I'm not a word master. I hope you've gotten my point across to you. Thank you.
So,
The law comes from the judge. said a lot of stuff up here that you didn't hear from the stand. It's not evidence, it's noise. The fact that he's passionate about it doesn't make it less noise. He says he's not making a dime, but the doctor's getting rich. That's not evidence in the case, unless everybody assumes that every doctor is rich. It's also not evidence in the case that he says I wasn't making a dime. Okay? Rules and regs, if I may have Defense Exhibit J. Mr. Leroy, in this context, and if you remember my cross to Mr. Leroy, he pointed out that he was operating under the police department rules and the health department rules. They're both rules. And he also pointed out, and we pointed out to several witnesses, that the rules with respect to checks only applies if there isn't an independent, probable cause to believe that a suspect is not entitled to the medical cannabis defense. If the medical cannabis defense is in the Rule J, doesn't apply, there's even no necessity to do checks, but they did checks anyway. He wants the testimony of the police officers to be disbelieved when it hurts him, and he wants you to believe the police officers when it helps him. One of the things that you're going to find on the tape that you listen to from Dr. Berg is, look, he's warning a first-time patient. You know, one of the side effects of regular medical marijuana use is paranoia. And that's what you just saw. That's what you just saw. He wants you to believe that Mr. Leroy went out and got the new rules from the Department of Health and found that the new rules would create a trap for him, and that's why they went out and got him. That's ridiculous. He wants you to say that he believed Mr. Fanunu was in danger of imminent harm when you listen to the tape of the sale, which he wants you to believe it's not a sale because it wasn't mine, I was selling for somebody else. That's not a defense. But he wants you to believe that there was imminent harm, or he reasonably believed that there was imminent harm, even when Officer Fanunu says, no, I'm not going to smoke any now, I'm driving. How is that imminent? It's not. It's not imminent. He wants you to exercise his fourth branch of government and find him not guilty. It's not a fourth branch of government. That's basically a confession when he gave his statement that he violated the law. It's basically he violated the law, but find me not guilty anyway. That's what he's asking you to do. That's improper. You're taking a sworn oath to uphold the law. He wants you to believe that Officer Fanunu, even though he was closed, out of the kindness of his heart, he agreed to allow him to come up on a Saturday and buy drugs. That's not true. That's recorded. That's not true. That's not the conversation that he had with Officer Fanunu. What he told Officer Fanunu wasn't that he was closed. He looked at the time and he said, well, where are you? In Hilo. Okay, come on up because we close at 4. He wasn't keeping the hours open because he thought somebody was in pain. No, he told them straight up, well, we normally only accept new applicants on Monday, Wednesdays, and Fridays, and this is Saturday, and we're going to close at 4, but he can get up here before we close. Well, then fine. He gives you all this stuff about the law, and then he admits that he broke the law. He admitted that what he used to do is, new patient came in, I wasn't the caregiver for that patient, so what I would do is I would terminate my caregiver status for this patient over here, and I would sign up this patient as my new caregiver, as my new patient for caregiving purposes. I'd make a transaction with them, and then I would terminate that agreement and go back and pick up this one. That tells you he knows what the law was, and he was just trying to work around it. And then for whatever reason, he got tired of doing all that paperwork. And so here we are. That's not a defense. He says, who is Detective Officer Leroy? Well, I sued Officer Leroy. Well, you know what? The evidence in this case, including the recordings at the Department of Health, where he makes statements, is the evidence is that if he don't agree with you, he's going to sue you, he's going to threaten to sue you. That's just the way he is. That's not a defense. Mr. Leroy is not prejudiced against him just because he threatens to sue him. He threatens to sue everybody. I guess we're all against him. That's nonsense. Again, look at what he says on entrapment. He wants you to believe that he's entrapped, notwithstanding the fact that he's advertising for people to come up there. And the only thing Officer Fanunu does when he shows up there is buy cannabis from the defendant. And now he wants to say, well, it wasn't mine, I'm just selling other people's cannabis. It's not drug paraphernalia because our investigator, our criminalist testified, well, it didn't test positive. Well, listen to what he says on the tape. He represents it as drug paraphernalia. He knows exactly what drug paraphernalia does. Why does he know? His prior experience, he knows. His prior convictions, he knows. Okay? The fact that it didn't test positive this time doesn't make it not drug paraphernalia when he testifies on the stand that he knew it was drug paraphernalia. These types of cases are very difficult. The state understands that. The state's prosecution theory never changed in this case. It didn't change. You can't sell to someone who's not your patient. Bottom line. That's the law. He wants you to ignore all of it. I ask that you return a verdict that speaks the truth. Thank you.
Calling CR 15-1-391, State of Hawaii versus Michael Ruggles for jury trial. Please state your appearances.
Afternoon, Your Honor. Deputy Prosecuting Attorneys Rick Domerville and Pamaheo Kahoho Palahala for the state.
Good afternoon.
Good afternoon, Your Honor. Mike Ruggles, pro se, with standby counsel, Stanton or Shiro.
Good afternoon. So our jurors are present. Let's see. Will the foreperson please stand and identify himself or herself?
My name is Mitchell Tapp.
Mr. Tapp, has the jury reached a verdict in regard to this case?
We have,
Are the appropriate verdict forms signed and dated?
they are.
Please present them to my law. them in a seat.
We, the jury, in this case, find the defendant not guilty of the offense of promoting a detrimental drug in the first degree, count 1. We, the jury, in this case, find the defendant not guilty of the offense of prohibited acts related to drug paraphernalia, count 2.
Okay. Is there a request for the holding of the jury? So, based upon the verdict entered by the jury, the court will enter judgments of acquittal. So, I'm going to thank the jury very, very much for its service.